One of the most common questions we get is whether a will or trust is valid under Arizona law, whether the person who signed it was of sound mind or had mental capacity. Hi, I'm Kent Berk from the Scottsdale, Arizona law firm Berk Law Group, where we specialize in probate, trust, and estate litigation, disputes, and contests. I'm going to briefly explain the standard for testamentary capacity in Arizona because it has a very specific standard and test whether a person has testamentary capacity. First, does the person have the ability to know the natural objects of their bounty? Do they know or have the ability to know who their family members are, such that they would naturally consider leaving their estate to them? They don't have to leave it to those people, just have the ability to know who their family members are. Second, do they understand the nature and extent of their assets? Do they have a basic understanding of how much property they have, a couple of investment accounts and a piece of real estate? They don't have to understand it down to the last penny, but just a basic understanding of the nature and extent of their assets. And third and finally, they have to understand the nature and effect of the testamentary instrument. Do they have the ability to understand that this is a will that will dictate where their property goes when they die? If they have the ability to understand each of those three elements under Arizona law, the person will be deemed to have testamentary capacity. A couple of other quick rules. First, everyone is presumed to have testamentary capacity and have executed their documents with testamentary capacity and without being unduly influenced. As a result, anyone who is contesting the validity of a will or a trust has the burden of overcoming that presumption. So let's say you want to challenge whether someone had testamentary capacity to execute a will or a trust. How can you do that? There are several ways. One, if the person is still alive, then they can undergo an in-person neuropsychological evaluation where they have to undergo several tests of various cognitive abilities, as well as usually just an interview, a discussion. That's one way. Second, if you're trying to evaluate whether someone had testamentary capacity in the past and they're deceased, for example, you could gather all the medical and other records and have a forensic neuropsychological evaluation done, basically a retrospective evaluation, certainly interviewing the drafting attorney or anyone else that was present at the actual time that the documents were executed, other witnesses who were dealing with the person at and around the time that the documents were executed, and depending on the circumstances, there may be a variety of other options. If you have any questions, if you want help trying to evaluate whether a will or a trust is valid based on testamentary capacity or any other questions, please don't hesitate to contact us. Thank you.